Okay, great. We now begin on the second session in this class. So, actually, it is a time, a period to work and also repose over the weekend, and the exam week should be soon. So it is one of a exam strategy to manage yourself in a wise manner. You can say. How do you see? Do you enjoy classic music with melodies? So you have some time of pinnacle with a pompous circumstances composed by Elder. It's really elegant. And many scholars you encounter through the pages have the idea in an analogy with the music and other composers and performers. Actually, in Soviet Union, the communist ideology is absolute. But it's it was proven. Do you agree that it is not a panacea in rather exposed to many weaknesses about disagreements and the dissension and some mobilization to the ethnic movements and national independence. Then, how do you consider the judicial and quasi-judicial institutions in Soviet Union? It is a former name of a Russian Federation. And in this case, you can see, as I've said, some dominance of a political power, and it is actually the least dangerous branch in Russia. It operates separately from, but it's by no means equal to the other branches of government. So among the two factors, one was removed in practice. They are not co-equal, and actually see the gate in mutual checkups, check and balances. It is not feasible in the expected dynamism of a Soviet government. In most socialist systems, members of the highest courts are elected by responsible to and recallable by the legislature. And so, in some socialist countries, notably the USSR, decisions of the highest court in the land are in principle reviewable by a division of the legislature. As one looks at the separate countries, however, two distinct groupings emerge with regard to structure and composition of regular courts. These are the USSR model and the Polish model, notable, and should be pertinent to later discussions in this class. More socialist countries seem to follow the Soviet model. These include the PRC, Hungary, Mongolia, and Cuba, but a significant minority adhere to the Polish model. Because of these differences, our analysis of the regular course will begin with the Soviet model and then proceed to the Polish model. In our discussion of special codes, we will turn to a unified treatment of all the socialist systems. So we firstly brief the regular course which undertake the role and responsibility concerning general civil and criminal matters. We will examine those permanent institutions which administer socialist law on a day-to-day basis. The term court is used in a broad sense to include not just courts, strict sense, but also all agencies that resolve disputes of one form or another by resorting to proceedings that are quasi-judicial or arbitrary in nature. And there are you can find a great patronage about the arbitral proceedings. You can see various forms committed to specific arbitration of a specific affairs. More specifically, the institutions include the regular courts, the state arbitras economic courts, what you call a Foreign Trade Arbitration Commission, Maritime Arbitration Commission, commissions on labor disputes, administrative commissions, commissions on the affairs of juveniles, commonwealth courts, and the military courts. But interchangeably, you may find the corresponding institutions. So, for example, with the counterparts of liberal states, for example, the military courts, that is also the case and dealt with in constitutional promise in Korea also, and also we have a special courts in disposed in special terms and commission dealing with the case of United States and also other countries. And also it is interesting to see what a commission on labor disputes. It evokes the idea adopted by a German practice. You have been introduced special branches in court institutions in Germany. The primary function of Soviet court is to apply a predetermined law to the facts of a given case. The Supreme Courts have the additional function of superintending, coordinating the general application of law by the lower courts and articulating the general principles of the law based on insights gained from a series of decisions dealing with a specific aspects of the law. In a handful of instances, the Soviet court operates as a creative adjudicator. Depending on the attainable intention of the legislator, the Soviet judge may view the law either as that of a judicial slot machine or a creative adjudicator. The true situation is that in the exercise of its constitutional authority, the Soviet legislature delegates some discretion to the judge, but in doing so, it defines the outer parameters of such discretion. So, virtually controlled by legislature and specifically granted a limited scope of authority about the lawmaking powers. And also you can see the context of administration, engineered by and led by Supreme Courts in Soviet Union, superintending and coordinating. So actually the hierarchy of judiciary, measuring with each rank, is rather disposed in a similar fashion with the counterpart. Otherwise, you can see some context of a control, in the prerogative of presidium and other collegial authority. You can see plenum in later part, and also a presidium instituted through various ranks of a courts and a commissions. The judge is thereby authorized to tailor the judgment in the case to meet the specific circumstances of the case. This is particularly the situation in criminal law, where the criminal statute established the minimum and maximum punishments for persons convicted under particular code article, but delegates judges the power to determine the exact punishment for the individual cases. And of course, you can see the same operation in liberal context, but the practice also differs in sheer area. For example, that we learned two dimensions: a prerogative and a normal class of a Soviet denizen in purpose of a criminal classification, for example. And the statutory discretion may be granted in more extended and loose context. So in that light, the socialist judges may have more or leeways to arbitrate the final punishment, but the authority of a corresponding lesser body is absolute. So politically produce some other results against the normal conception of a liberalist lawyers. So proportionality principle, as I've said, may come in extreme context and occasionally reported in the newspaper articles about bribery of a governmental employees and officers. And recently, sexual harassment of a child and a junior was condemned seriously by means of capital punishment, death penalty. How do you agree on the sentence? Of course, that is a serious and nowadays also in liberal states. In the area of civil law, the legislation delegates to judges the power to construe and enforce private contracts so as to educate the parties and further the cause of communism. So you now note that there is some typical interplay with a private contract. So central control of the economy. How do you see it? It is interwoven or to produce the private justice, civil justice. So the court are expected to educate the parties, and they also assume the role to inculcate the cause of communism. It is prurient, and also you are greedy and should be corrected politically for a new concept of social man, socialist man. You can see. And also, I have said you have extent of a plan contract, prearranged to meet the state needs by a government, and also so they force the party to enter the contract. On one hand, that is critical part, distinguishable from a liberal concept of contract. Also, of course, we have discussed limitations of contract. Now, a profile of the transformation of capitalist society, and is a advanced form of a socialist, a socialist response to adjust. But you never see the kind of extreme power to force the party to enter the contract, compulsory command. And of course, the plan contract also disputed in economic cause, concerning the damages and the breach of contract and others. So you have two types of dealings involving involving the contract law. In all of these instances, the discretion of judges is defined, structured, and confined by the legislature. Where the lawmaker wishes to strip the judge of all discretionary authority, it simply adopts a peremptory law, which the judge must apply mechanically to the facts of a given case. This is the situation when the law of constitutional or a criminal or family law imposes certain specific duties on citizens. The Soviet judge then has no choice but to enforce such duties, even if he thinks that they will lead to an unjust result. Under the general heading of regular courts, we will discuss the courts which exercise general civil and criminal jurisdiction. At the lowest level within the regular system, the same judges generally handle both civil and criminal cases on alternate days. For the judicial ladder, one begins to notice some form of specialization among the judges. They assign exclusively to civil or criminal cases. As a rule, the superior courts are organized into chambers with a separate judges sitting in the respective chambers. An overwhelming majority, approximately 85% of cases that are handled by Soviet courts are civil cases. So you can see the separate context, which varies across the area. For example, there is the area usually defined in preemptive law, and that requires the judge to respond mechanically to uphold the legislative command. You see. And in other case, you can see the law as a creative adjudicator, or delegated in the scope of a plenary discretion by the legislature. The structure of Soviet courts is dictated by the nature of Soviet federal system. The USSR is a complex federation of federations. For purposes of political administration, the USSR is subdivided into union republics, which roughly correspond to the states in the United States, and autonomous republics, and autonomous regions, autonomous areas, cities, towns, and villages. So you can see the geographical ranks in power and a governance purpose through the a smallest unit, towns and villages. Usually, the adjective autonomous denotes a lower rank of a geographical territory. Autonomous republic is a constitution part of a union republic. And there are 15 union republics in the USSR. The autonomous region is a constituent part of a union republic. The only autonomous republics that are subdivided into autonomous regions are RSFSR, Georgia, Azerbaijan, and Turkmenistan. These names usually denote the ethnic region. So I see these republics now considered independent nation. And in turn, the autonomous area is constitute part of an autonomous region. Not all autonomous regions are subdivided into autonomous areas. In those autonomous regions where there are no autonomous areas, the next administrative subdivision is the city, town, or village. Because of Soviet federal structure, there are two parallel systems of codes in the USSR: federal codes and Union Republic codes. The federal codes consist only of the USSR Supreme Court and the national network of military tribunals. So it is simple and concise form, but actually assumes the role as a final arbitrator about federal issues in Russia. The Union Republic codes, on the other hand, are arranged into three levels: People's District Codes, Intermediate Codes, and the Supreme Court of the Union Republic. So now you can note the differences from the federal system of the United States. So the federal interplay is more intense in the United States, given many 95 or virtually close to 100 federal district code in the United States, and the 13 circuit codes to perform the appellate review and also other context of jurisdiction, and one federal Supreme Court. That is not the case in Soviet Union. Just one federal court, USSR Supreme Court. But we have three levels of courts in state context: Union Republican Code, which correspond with most of national practices. And in those union republics where there are no autonomous republics, autonomous region, autonomous areas, or city codes with the status of an intermediate code, there are only two levels of code: the People's District Codes and the Union Republican Supreme Courts. The People's District Codes are the courts of first instance in both civil and criminal matters. It is estimated that the People's District Courts handle over 90% of all civil and criminal trials in the RSFSR. Judges of People's District Court are elected by citizens of the corresponding district or city. So they are elected and also removable in collegial fashion. So interesting. And you can have some concept which could be correct in a concept of a court length, a People's District Court, and Intermediate Court, Supreme Court. So it constitutes kind of ladder in terms of a appellate review, and but in rare cases, the higher court may advance to see the case in the first instance. So they actually have a limited context of original jurisdiction, as we see in also in rare cases of United States Supreme Court. In each district, 2 or more judges may be elected, depending on the estimated caseload of the district in question. In most cases, however, there is only 1 people judge elected for each judicial district of People's District Court. The number of judges as well as the number of lay judges to be elected for each People's District Court is determined by the Executive Committee of the Legislative Council that stands immediately above the judicial district in question. In a judicial district where more than 1 people judge is elected, one of them is designated as the presiding judge by the city or district council. So we have been easy, relatively easy to get through. So what the presiding judge also is practiced in Korea. You can see the caseload is one of factors to decide the size of a court jurisdiction, and also so the concept of public policy and administration usually come in a similar light and apprehension. The next level courts are the intermediate courts, referred to by the generic name of regional courts. In certain instances, specifically designated by law, these intermediate courts operate as courts of first instance in criminal matters. Without assigning any specific category of civil cases to these courts, the law permits them to assume primary jurisdiction over any civil matter. As a matter of general practice, they assert their discretionary primary civil jurisdiction quite sparingly. Among the major functions of the intermediate courts is general supervision of the activities of the lower courts and cassational or supervisory review of judgments and decisions of the lower courts. Judges of the intermediate courts are elected by the corresponding legislative council. An intermediate court consists of a president, a flexible number of vice presidents, associate judges, and lay judges. Lay judges are used only when the court is sitting as a court of first instance. The court is subdivided into a civil chamber and a criminal chamber and has a presidium. Individual chambers sit as courts of a primary jurisdiction in civil and criminal cases. Sorry, actually, for a severe cold, I lost my voice significantly. As a court of a first instance, the chamber panel consists of 1 law judge and 2 lay assessors. But when the chamber sits as a court of cassational review, the panel is composed of 3 law judges only. The presidium of court, on the other hand, serves as a court of a supervisory review. The presiding judge of each of chambers of this court, as well as the members of the presidium, are appointed by the executive committee of the corresponding legislative council. judicial assignment to the individual chambers of court is by order of the presiding judge. The next step in the hierarchy of courts is Supreme Court of the Union Republic. It is the highest court in matters of Union Republic, the Union Republican law. So, state law interchangeably with the federal system of the United States. Its decisions on Union Republican law are not subject to further cassational review, but only to a limited supervisory review by the USSR Supreme Court on one of two grounds. So you have some ideas in comparison about the institution of certiorari practiced by a Supreme Court of the United States. So what the grounds are? If the decision violates either federal law or the interest of another Union Republic, so and interstate matters, and also the case may involve the interest of federal law. And you can see the doctrine of federal question to ground the federal jurisdiction also. One immutable principle of Soviet federal-state relations is that no case decided by Union Republic Court may be reviewed by the USSR Supreme Court unless the case has passed through the Union Republican Supreme Court. And that is not the case in the United States. The case may be directly appealed to the federal case. For example, a fundamental human rights are concerned, and habeas corpus. You know one of legal institutions, notable in the United States and common law legal system. So the federal court maximizes the jurisdiction in first instance in the United States, and also maybe relegated up through the higher court of federal higher court. Even may be dealt in the federal district court if involving the federal question, and so actually complicated and intersection between a state and a federal authoritative court. The critical inquiry lies in the fact if it is a federal question, it can be viewed involving a diverse concern among different states. In USSR, it is precondition that the case should pass through the Union Republican Supreme Court if it is reviewable by USSR Supreme Court. You can see the Union Republican Supreme Court and exercise general supervision of all the other courts in the Union Republic through the exercise of its cassational and supervisory jurisdictions. In isolated instances, the court also acts as a court of a first instance. However, the law does not specify which cases fall within the primary jurisdiction of this court. Rather, the court asserts primary jurisdiction in one of two ways. First, it may seize any case that wishes to try as a court of first instance. Second, it may try cases referred to it by the procurator of the Union Republic. The size of the Union Republican Supreme Court is determined by Union Republican law, which takes into consideration the anticipated caseload of the court. Typically, it includes one president, a vice president, associate justices, and lay assessors. The president and vice presidents of the court generally are not assigned to any specific chamber of the court. The court is divided into a civil chamber, a criminal chamber, and plenum, en banc session of the court. So it is not a standing organ in the court. It is expected to meet once bi-monthly in some cases, and in the interval of 3 months usually. The presidium consists of chairman of the court, his vice chairman, and some associate justices of court. The size is determined by the Presidium of Supreme Soviet of the Union Republic. The Presidium of Supreme Court sits only as a court of a supervisory review of judgments and decisions of the individual chamber. It may also sit as a court of the retrial if new evidence is discovered which warrants the redetermination of case that was initially tried by a chamber of the Supreme Court acting as a court of first instance. Decisions of Presidium are by a simple majority vote. So this is same as the practice of South Korea. You can see in provision of a civil procedure, it stipulates the case, the entire forum of justices are required to address. For example, new evidence and a requirement to compel a retrial should be treated. But actually, conceptually similar with the Presidium of Supreme Court in Soviet Union. However, differs in many contexts, as you see. For example, the Presidium exercise more hierarchy to derogate the discretion of a lower court justices, and also omnipresent in dominance. So, and you have some ideas as borrowed from a constitutional code of South Korea. You have a difference. For example, it envisaged a simple majority scheme. That is not the case in Constitution Code of Korea. And weighted majority, for example, 2/3, and that scheme also was adopted in some extreme, some special context by Soviet authority also. Whenever the Presidium sits as a court of a supervisory review, its sessions must be attended by the procurator of the Union Republic, who presents his opinion to the court on the law relating to the particular case. The plenum of Supreme Court is the en banc session of the court and consists of chairman of the court, his vice chairman, and all the associate justices of the court, with the exception of the lay judges. It meets at least once every 3 months, and the sessions must be attended by the procurator of the Union Republic to present his opinion on the questions of law. Decisions of plenum are taken by a simple majority vote. The duties of the plenum court include handing down guiding interpretations of laws in force. So that is not the case we see in common law jurisdiction and also in South Korea. assigning justices to the individual chambers of court and receiving and approving the reports of presidents of the individual chambers of the court regarding the activities of their respective chambers. So you have some sensibility about a centralization tendency. In some union republics, the plenum also undertakes supervisory review of decisions of the presidium of the court. The highest court in the USSR is the Supreme Court of the USSR. Its members are elected by Supreme Soviet of the USSR. The court consists of one civil chamber, one criminal chamber, one military chamber, and a plenum. The size of the court is established by the Supreme Court, which takes into consideration the anticipated caseload of the court and its other administrative responsibilities. For example, the court that was elected on April 19, 1979 consists of 19 justices and 49 lay assessors. So it now entertains a fair number of justices and lay assessors that is not identifiable in any other liberalist context. For example, the United States have 9 Supreme Court justices, and that is also 13. And in Korea, 9 justices in Constitutional Court of Korea. The justices will assign as follows: 6 to criminal division, 4 to the civil division, and 6 to the military division. The president of court and the 2 vice presidents do not sit in any particular division. The 15 chief justices of the Union Republic, so we have 15 geographical sections covering Union Republic, and therefore we have 15 chief justices of the Union Republic Supreme Court, ex officio members of the USSR Supreme Court. These ex officio members only participate in the in-bank sessions of the court. The plenum of the USSR Supreme Court meets at least once every 3 months. The court exercises not only a primary but also cassational and supervisory jurisdictions. However, only the military division of the court acts as a court of a cassational review. Since the decisions of the Union Republic Supreme Courts are not subject to cassational review by the USSR Supreme Court, it follows that the civil and criminal chambers of the USSR Supreme Court do not have any cassational jurisdiction. As a court of cassational instance, the military division reviews the decisions of royal military tribunals, but as a court of a supervisory review, the 3 divisions of courts is respectively to review the decisions of all corresponding lower courts in the USSR. The Supreme Court's plenum renders guiding interpretations of USSR laws. So now we welcome some of crucial part of this discourse, which expect to show general principles of Soviet court organization. Sorry, I failed to subdivide it into 6 points. So you need to be a little more attentive since it's a crucial part in my class purpose. There are certain general principles that govern the organization of Soviet regular courts. The first of such principles is that all judges must be elected. Even though all Soviet judges are civil servants and are administratively integrated into the system of Ministry of Justice, they are all elected. The People's District Court judges are elected directly by the people in the judicial district. Judges of the intermediate courts of Supreme Courts of the Union Republics as well as the USSR Supreme Court are elected by the corresponding levels of legislative councils. Any Soviet citizen who is at least 25 years old and possesses the right to vote may be elected a judge or lay assessor in the USSR. So it is the same age stipulated in United States Constitutions. Dealing with a representative house is age qualification, 25 years. And voting eligibility in South Korea, what age? 20 years. The right to nominate candidates for judicial office is granted to the respective social organizations, trade unions, youth organizations, general meetings of workers' collectives, employees, and members of the armed forces. And what is second principle? Flowing from the foregoing principle is the second principle of Soviet Code organization, to say the accountability of judges to those who elected them. Soviet judges are required to give periodic reports of the activities to the bodies that elected them. Any individual judge who is found to be wanting in the discharge of his judicial commission may be recalled by his electors prior to the completion of his term of office. The procedure for the recall of judges is regulated by a special statute. What this specifically means is the Supreme Court of the USSR, the highest judicial body in the country, is elected by and accountable to and recallable by the Supreme Soviet of the USSR. The USSR Supreme Court is required to submit the report of its work to the Supreme Soviet of the USSR at least once a year. The report typically informs the legislature of the types of cases decided, the particular problems that face the courts, any perceived overloading of the dockets of the courts, and recommendations on how to reduce such overload. So actually, that involves a important part of a administration, and for example, you can see that is a matter of calls, for example, concerning WTO organizations, and we have a a remedial context of institutions, panels, appellate body, and that is pivotal to ensure the scheme of a WTO commission, but in more a foregrounded a element, you can see some of a administration involving a control of a state economic policy, a member state economic policy in advance, in preordained a fashion, and may interact to remedy before the actual controversy or dispute may arise. Preventive measure and also other remedial purpose of negotiation may be utilized to keep a fair and a liberal trade, liberal ideas of international trade. The third principle of Soviet Code organization is a recognition of the independence of judges and their subordination only to the law. So what I said is that the reform of a code also one of public issue now in Korea, and how to constitute the proper number of seats, justices, for example, and also the Constitutional Court now discussed about the institutional reform. Pursuant to the fundamental principles of core organization of the USSR and the Union and the autonomous republics, criminal action may not be initiated against the judge or lay assessor, nor may he be arrested or removed from office without the prior consent of the presidium of a corresponding legislative council. And the extent of any subjugation from legislative authority or any the compulsory nature of legislative intervention is one factor now discussed in Korea about the independent judiciary. Do you see if it can harm the independent judiciary? It's a matter of a constitutional framework and also how to ensure many virtues now incorporated in the Korean Constitution is a matter, actually. In an effort to further secure the independence of judges, Soviet law also established a special disciplinary procedure for dealing with violations of the law or any misconduct by members of judiciary. Thus, for example, disciplinary actions against judges of the RSFSR are governed by a special statute on the disciplinary responsibility of judges of RSFSR. Similarly, disciplinary actions against judges of federal courts are governed by a special procedure established by federal law. It should be noted, however, that the independence of Soviet judges was never intended to be absolute. It is carefully circumscribed operational independence. So let us take the vivid expression given by a leading Soviet commentator. Interesting. Independence of judges may not, of course, be understood to mean the independence from the socialist state. The court is an organ of the Soviet state, and as such it promotes the policies of state. The policies of Communist Party guarantees the execution of Soviet laws, which are a reflection of the will of the people. But for the court to more successfully implement the policies of party and the Soviet government, it must be shielded from extraneous influences and interferences. The same Soviet writer further notes, while it maintains its independence in the decision of individual cases, the Soviet court at the same time, in all of its activities, is closely linked with the local party and state and social organizations. It assists the local organs in the performance of their economic and political tasks. Conversely, the local party organs and local Soviets of workers' deputies assist the courts in all possible ways in the successful administration of justice. They listen to reports from the judges regarding the state of the fight against crimes and other violations of the law, bring to the attention of the courts any noted deficiencies in the work of the court, and adopt the measures aimed at the elimination of such deficiencies. However, they are not empowered to compel the courts to enter a particular judgment in case pending before the court. Every court in the USSR is subject to control from the party in the sense that these courts operate under the political directives given by the party. Soviet scholars take the position that the theory according to which the courts are supposed to be totally independent of the political branches of government is a bourgeois myth, and that the courts are not and cannot be insulated from the politics of the ruling class in any given society. The following passage, taken from a leading Soviet commentary summarized the dominant Soviet position. What is that? In the history of human society, there has never existed a state in which there were no courts. What the emergence of private property, a process which paralleled the emergence of classes, emerged the state and the court as an instrument of the state. To the extent that the court is a constituent element of state, all of its activities are shaped by the will of the class in whose hands the state power is vested. So, as I said, a prospect about lawless and statist community. Do you see it is a brutal myth? Then what does it mean in ways of independent judiciary? What conscience of judges in this society? Accordingly, Soviet scholars assert in all states the court is subservient to and operates as an instrument of political authority. One illustration may be found in a recent court tendency about a property right. It involves Article 1 or Article 1st and 2nd of Korean Civil Code. How do you assess the extent of property right in adaptation to the social needs? For example, how much can it be interfered to address the neighboring needs, substitute in case, and what caused the condemnation, the legitimate condemnation, and just compensation, and how much is it pertinent about abuse of a property right. What about the faith and fiduciary duty of a parties involving a civil law relationships? The Soviet Code is not and does not lay claim to being a political or ideologically neutral. It is neither above nor outside of politics. It is an integral part of the overall political process within the Soviet state. Another general principle of Soviet court organization is the collegiality of the court and the use of lay judges in all trial proceedings. Even when the superior courts act as courts of first instance, the trial panel must include 2 lay assessors for every judge. The court trial panel consists of only 1 law judge, however, when it sits as an ad hoc administrative court. In the People's District Courts, judges and lay assessors decide both questions of law and fact. Lay assessors have the same procedural standing as the law judge. As such, they have equal access to all the facts in the case, to the pretrial file, and the right to vote on questions of law and fact. So the role assumed by both judicial personnel are the same to the judges of Korea and other United States. They engage in both aspects of a dispute. But that is a point of difference, but you can see a similar context about the primacy of law judges. They possess a power position, and he tends to lead the court his way. And decisions are by a simple majority vote. Before the votes on the issues of law, the law judge generally instructs the lay assessors on the law. the practice is for the low judge to cast his vote less, so that his position would not unduly influence the opinion of the lay assessors. The low judge, therefore, is generally dominant figure on the bench. By virtue of his he also presides at the trial, but that privilege may be assigned to one of the lay judges. In the true sense of the word, the low judge is the master of trial proceedings. It is very rare for him to be in the minority position on any question that is put to a vote. So we have same dynamism in court proceedings. Like the low judge, the lay assessors are all elected, but the low judge is elected for a 5-year term, while the lay assessors are elected for 2.5-year terms. Every 2.5 years, a pool of lay assessors is elected throughout the country. A lay assessor may not be required to serve for more than 2 weeks per year. They are generally summoned to serve on the court that has jurisdiction of their place of residence. Like the low judge, the lay assessors are accountable to and removable by those who elected them. Any Soviet citizen who is 25 years old and possesses the right to vote may be elected a lay assessor. Lay assessors of the People's District Courts are elected at general meetings of workers, employees, and peasants convened at their place of residence. In electing a pool of lay assessors, a special effort is made to reflect the cross-section of the population. The jury selection may be viewed in a similar context, but you have been careful to discern the difference. For example, a typical pool was composed as follows. A total of 203 lay assessors were elected throughout the USSR, of which 51.6% were workers and peasants. 48.4% were members of the working intelligentsia, salary state employees, students and pensioners and housewives. Of this number, 44.7% were members of CPSU, Communist Party of Soviet Union, and 55.3% were not members of the party. So half on half statistics. Also, of total number, 3.7% were women and 56.7% were men. Those lay assessors who are gainfully employed outside of the home, except those who are self-employed, continue to draw their regular salaries from their regular employers during service as lay assessors. If they have traveled to another city, they are fully reimbursed for out-of-pocket expenses from funds of the court. So they are actually not a professional jurist, and there are a periodic limited not standing body actually in the context of the work performance, and their reimbursement is limited to the incidental expenses in the course of the carriage of a duty. Self-employed and collective farm workers are paid per diem expenses for each day that they take off from work in order to serve as assessors. The less general principle of Soviet co-organization is what Soviet commentators refer to as the principle of socialist legality. It is a very essential concept in understanding of a socialist legal tradition. And you have some a fossil point about this concept by a leading Soviet commentator. The principle of socialist legality means that in our Soviet state, every organ of state power and state administration, as well as every institution, organization, official, and citizen, must conform his or his actions to the provisions of Soviet law. In the words of Vladimir Lenin, legality cannot be localized to Kaluga or to Kazan. It must be uniform throughout Russia and even uniform for the whole Federation of a Soviet Republic. So it is a vital mechanics to realize the Soviet Commission also. Then what is a Soviet judicial style? As we have already noted, this is one of basis for classical or legal system in families of law. So it is factor, and as I've said, the Soviet judicial style is prototypical judicial style of all other socialist countries. Actually, original state. For the evangelical mission of a communist unification, or the Soviet judicial style is different from that of a typical civil law country, such as France, or typical common law countries, such as England of the United States. It is much closer, however, to the French judicial style than it is to the common law style. A typical Soviet judicial opinion consists of 4 parts, as I have introduced in the beginning of this class. And as I've said, you have some comments to let you have a basic comprehension about the publication, and also publication of court opinion, and also the responsibility is assigned to the bulletin of Supreme Court in question. For the class purpose, we now have 2 cases to elucidate judicial style of the Soviet Union. That should be for the next class. And the Friday class should be final in the class schedule, but we have scope of discussions on delivery. So I promise to facilitate the rest of a code, varying course involving economic course, arbitration commission, and I promise to finalize. Originally, I planned to introduce a more postmodern context of a comparative research, which is signed for the last week of this term, but I failed to follow up with that. Some of a contemporary importance for a informal context of our discourse. I like to present some of them. So may visit my office in summer vacation or others. Okay. Let's see you in the next class on Friday. Thank you for your